quantity pre-GST without accounting for the GST liability. The tender process was delayed and they entered into the contract post-GST. But even then, my lord, they are not giving it. So even the circular which they have issued, they take care of circumstances even in pre and post GST contracts. There are several contracts to that effect. Annexure 5, this circular itself issues the word post GST also.
Annexure 5 is at
page 196, my lord.
GST and post GST अवधि में भुगतान पर उत्पन्न स्थिति हेतु मार्गदर्शन स्पष्ट करें.
Yes.
Very well, you seek instruction and file counsel.
Yes, madam. Well,
Writ
for which
petition
time,
has
madam, we can leave granted.
none counsel for the respondent. When counsel for the petitioner submits that petitioner has been waiting for reimbursement of the additional impact of tax due to implementation of GST regime with effect from 1st July 2017. After adjusting the tax benefit of pre-GST regime, which is already embedded in the contract value in respect of the work awarded to the petitioner, while SBD number 1 of 2018-19 dated 22nd June 2018, Annexure 2. Stop. He submits that he relies upon Annexure 5, letter of the Department of Guidelines of the Department of Commercial Taxes, Government of Jharkhand, bearing letter number 1421 within bracket Anu dated 14 July 21, and also the guidelines laid down by the Ministry of Road Transport and Highways at Annexure.
It's same part of Annexure 5 only, madam.
Which encloses the guidelines of the Ministry of Road Transport and Highways dated 19th November 2018. Then counsel for the petitioner submits that despite instructions from the chief engineer to the concerned engineers and representations by the Annexure 6 and representation made by the petitioner by the Annexure 7, the matter is lying at the end of the respondent. Annexure 7, 8, etc. The matter is lying with the respondents. Stop. He submits that on similar issues, this court has, in a batch of writ petitions led by WPT number 2108 of 2019, Annexure 9, directed the state respondents to seek instruction by order dated 14 December 21. Stop. Parallel counsel for the state, Mr. Ashok Kumar Yadav, GA1, prays for is allowed 4 weeks' time to seek instruction and file counter affidavit. Petitioner, if so advised, may file reply thereto. Stop. Let the writ petition be tagged along with the batch of writ petitions led by WPT number so and so, so and so. Annexure 9, 2108 of 2009. उसमें जोड़ दिए clause 45.1 is the provision relating to tax liability in the agreement. Stop. Then counsel for the petitioner has also relied upon section 64A of the Sale of Goods Act 1931. Buttress his submission. Yes, Mr. Purmi.
One of the central issue involved in this case,
Yes.
whether the jurisdiction of the revisal authority under section 8 of the Act, under 108 of the Act, can be invoked at the instance of the SSC or not. That is the crux of the issue, Lordship. That is central issue involved in this case. Section 107 of the Act with appellate remedy. Section 108 deals with suo motu revision. I filed a revision petition before the divisional authority under section 108 of the Act, which is returned to me saying that no revision lies against an order passed by the subordinate authority under 108. It is a suo motu jurisdiction and appeal would lie against that order, and I am directed to file an appeal. That is a page, my lord, kindly see.
Counter affidavit is there in all the writ petitions.
Yes, my lord. In almost all the writ petitions, save and except 2 or 3 matters, and the rejoinders have been filed in maximum number of cases, my lord. Save and except few other matters, my lord. Last 3 matters.
Except, Mr. Purvi, except the conditions prescribed under the limiting conditions prescribed under section 108. What other rationale does the commissioner, the revisional authority have to relegate the SSE to the appellate remedy, in your understanding?
My lord, if I would say I will take a holistic view,
Yes.
I would submit, my lord, that the genesis of 108, my lord, before I go into that, I would say, if generally we have seen that the provisions of the Central Excise Act and Service Tax have been incorporated into the GST. But the beauty is that it is by a federal structure was there, GST Council was there, the state and central all deliberated, and the good provisions of the Central Act and the good provisions of the State Act were incorporated GST. I would say that under the Central Act, my lord, Central Excise Act or Service Tax, there was no provision like 108. But in all State VAT Act, always there was provision like 108. And under the State VAT law, the revision petitions were always maintainable, in spite of there being a appellate provision in the Act. I would say, my lord, so take for a while, without going into the judgments, without going into the statute provision, what is the rationale behind 108? My lord, the entire powers under the Act is under the GST. The difference between the earlier Act and the present Act is that the power under the Act has been delegated on different authorities. Some powers are on the proper officer. Some powers are on the commissioner in the board. Some powers are with the commissioner. Some powers are with the GST officers, state GST, central GST. So different powers under different sections have been reposed on different authorities. Now the proper, in my understanding, is the most powerful officer. They are the assessing officer, and they may be subordinate officers. The proper officers are the most powerful officers on whom the power of assessment is vested, and they are all maybe subordinate officers, and they are subordinate officers. The commissioner is never assessing authority. Now, my lord, the statute wants that the officer at the highest rank in the department must keep a supervisory or exercise a supervisory jurisdiction over the activities or actions or the orders passed by the subordinate authorities. The purpose behind 108 is what, my lord? Suppose take for a while.
All revisional powers are basically supervisory.
Supervisory, my lord. That is my point. I say, my lord, suppose there is no 107 appellate remedy, then whether the SSC would be remediless, whether a wrong order will attain finality, and the state can collect tax without authority of law and retain it, my answer would be no, my lord, because all the taxing provisions are subject to Article 265. And Article 265 says that no taxes shall be levied or collected. It cannot be levied, nor it can be collected, save by authority of law. It is a negative mandate. It is a negative mandate on the state. I may pay by mistake of law, but the state cannot levy or collect. So the mandate is on the state. It is a negative mandate. The Article 265 says, my lord, I will read that. Taxes shall not be imposed save by authority of law. No tax shall be levied or collected except by authority of law. Now, my lord, suppose a proper officer who is subordinate officer, he passes a wrong order.
Who is appearing like this? Just a minute, Mr. Kohli. कोर्ट मास्टर जरा ये देखिए कौन ऐसे पेड़ के नीचे अपील कर रहे हैं। ये वो लगता है फर्स्ट अपील के हटाइए। यस मिस्टर।
So, my lord, a subordinate officer or a proper officer who is subordinate officer, he passes a wrong order. He passes a wrong order which is without authority of law. Assuming that 107 is not there, then whether the state can retain that amount, and if the state cannot retain that amount, then what is the check and balance? Who will see into the orders? It is the revisionary authority, the commissioner. He will look into the orders and try to find out whether the taxes have been collected without authority of law. It is contrary to the mandatory provisions of the Act. It is against the public interest. If these are the conditions found in a particular order, then the authority will sure to revise it. Whether I go into appeal, I don't go into appeal. Whether I may be agreed, I may not be agreed. Because the negative mandate on Article 265 is not on me. The negative mandate is on the state. The state will say, gentlemen, you have paid extra tax, you have paid tax wrongly. Please come and take it back.
Ordinarily, in all revisional power, the revisional authority is required to examine three aspects. One, irregularity. Second, illegality. And third, propriety. As far as my memory goes and my limited understanding goes, these are the three requirements which the revisional authority has to examine in any lower court records. It doesn't say that he only has to see those which are against the revenue, only those records he has to examine. He has to examine the records whichever way, only to test whether they come or fall within these three mischiefs, whether it is an irregular order suffering from irregularity, illegality, or there is lack of propriety. Now, your argument which you are trying to develop, we may not be required to get into whether the order passed by an authority against the SSC is of such a nature which is not permissible under Article 265 of the Constitution of India. There might be myriad situation where the order might be suffering from illegality, irregularity, or impropriety. So, irrespective of the color of the order, the revisional authority has to see that the lower court or lower authority acts within the bounds of its jurisdiction.
Correct, my lord.
Basically, Article 227 is also a supervisory jurisdiction.
Very correct, my lord. Very correct, my lord.
So that concept flows and revisional power we exercise in 227 also. We do not undertake a merit-based review under 227.
Correct, my lord.
We do not substitute our view under 227. So that is the scope. And the appellate's court is a much larger scope where the merits of the decision, computation, etc., you can show so many papers, etc. These things have to be seen in the appeal. So in this kind of a broader understanding of the revisional power and specifically conferred under Section 108, which itself enumerates some of the conditions which are limiting, Section 102. Why should the revisional authority say that, no, I will not exercise that power? Does it mean that he can do so only suo motu and not on the basis of an application by an aggrieved person or being brought to his notice by way of an information by an aggrieved person? Is the understanding of the revisional authority to that effect? Otherwise, the whole purport of this section may go meaningless. So, I am speaking something which may appear to be in your favor and trying to understand the interpretation of the concerned provision in a broader canvas. So, basically, the court is wanting assistance on these lines from both the sides.
My lord, two things are here.
Yes.
When one says it is a suo motu jurisdiction, there is no denial of fact that it is in fact a suo motu jurisdiction. But there are two aspects of it. One, that I don't have a right to invoke this suo motu jurisdiction vested in the authority under 108, but I can bring to his notice. And thereafter, if he feels that 108 conditions exist in the case, on the basis of my information, he can revise the order. My point is that it is one thing to say that I have a right to invoke 108, and it is another thing to say that I can bring to his notice what are the irregularity or irrationality or whatever kind of erroneous order the subordinate authority has passed. That information I bring to his notice. Now it is up to him to examine and find out whether I can exercise power under 108 or not. Whereas my right under 107 is my valuable right vested on me. I can invoke that right. That is the only difference. Otherwise, there is no difference if they go by the basic tenets of law that both the provision 107 and 108 they are made out, they are laid down by the statute, by the legislature, only to ensure that no wrong order survives. The purpose is that. So, my lord, kindly have 108 first.
Yes.
There is two in requirement, my lord. This two in requirement, as your lordship said, that the irrationality of the order or irregularity of the order, then there is an addendum to that, my lord. There is a twin condition. It must be prejudicial to the interest of revenue. My lord, I take for a while. I say an order passed against SSC would never be prejudicial to the interest of revenue, because what is against me is in favor of the department.
No.
Then again, my lord, I go back to 265. I say,
In this section 108, is that the only condition in which the revisional power can be exercised? Let us read 108.
my lord, kindly see 108, my lord.
Yes.
My lord, may I read it, lordship?
Yes, yes.
My lord, in my compilation, it is page 19. That is volume 2, my lord.
Now we are reading from the book.
Or if your lordship have got the books with you, lordship, make lordship see the books also. Section 121. Section 108, my lord. Powers of revision authority. Subject to the provisions of section 121, I will take your lordship to 121. And any rules made thereunder, the revision authority may, on his own motion, or, my lord, or upon information received by him. The first is, my lord, on his own motion. Second, my lord, upon information received by him, or on the request from the Commissioner of Central Tax, call for and examine the records of any proceeding, and if he considers that any decision or order, my lord, here, if he considers, kindly note it, my lord, if he considers that any decision or order passed under this Act or the Central Goods and Service Tax Act or any officer subordinate to him, by any officer subordinate to him, is erroneous in so far as it is prejudicial to the interest of revenue.
Yes.
So there are two in requirement, my lord, and I will argue on that also. Simply an order being erroneous is not sufficient, or simply being erroneous, prejudicial to the interest of revenue is not sufficient. The two in requirement must be fulfilled, and is illegal, as the lordship said, improper, or has not taken into account certain material facts, whether available at the time of issuance of the said order or not, or in consequence of an observation by the Comptroller or Auditor General of India, he may, if necessary, stay the operation of such decision or order for such period as he deems fit, and after giving the person concerned an opportunity of being heard, and after making such further inquiry as may be necessary, pass such order as he thinks just and proper. So, my lord, under Article 226, substitution of the opinion of the court does not substitute it, they simply quash it. But here the power is wider. He thinks just and proper, including enhancing, modifying, annulling the said decision or order. The revision subsection 2, my lord. The revision authority shall not exercise any power under subsection 1 if A. The order has been subject to an appeal under 107 or 112 or 117 or 118, or the period specified under subsection 2 of 107 has not yet expired, or more than 3 years have expired after the passing of the decision or order sought to be revised, or the order has already been taken for revision under the section at an earlier stage, or the order has been passed in exercise of the powers under subsection 1, provided that the revision authority may pass an order under subsection 1 on any point which has not been raised or and decided in an appeal referred to in the clause. What is left out in appeal can be subject matter of 108 clause of subsection 2 before the expiry of the period of 1 year from the date of the order in such appeal, or before expiry of the period of 3 years referred to in the clause B of that subsection, whichever is latter. 3. Every order passed in revision under subsection 1 shall, subject to the provisions of section 113 or 117 or 118, be final and binding on the parties. If the said decision or order involves an issue which the appellate tribunal or high court has given its decision in some other proceeding, and an appeal to the high court or supreme court against such decision or appellate tribunal or against such decision of the appellate tribunal or high court is pending, the period spent between the date of decision of the appellate tribunal and the date of decision of the high court, or the date of decision of Supreme Court, or decision of the High Court and the date of decision of Supreme Court, shall be excluded in computing the period of limitation referred to in clause B of section 2, where proceedings for revision have been initiated by way of issue of notice under the section. 5. Where the issuance of an order under subsection 1 is stayed by the order of a court or appellate tribunal, the period of such stay shall be excluded in computing the period limitation referred to in clause B of section 2. 6, my lord. For the purposes of this section, the term record shall include all records relating to any proceeding under this act available at the time of examination by the revision authority. Decision shall include intimation given by any officer lower in rank than the revision authority.
Yes.
Then, my lord, also I would like to read 107, my lord, if your lordship permits.
Please.
107, my lord.
Just a minute.
Cut off pictures. अशोक, लेकिन झारखंड लिखा हुआ है, सेंट्रल लगा हुआ है। वॉल्यूम दिखाओ।
Mr. Kurmi,
My lord,
straight away it came to our mind that 263 of the Income Tax Act is a similar provision like the present one.
my lord,
And 264 of the IT Act is a general power of revision.
my lord,
So 263 limits it to an inquiry or an examination of records in relation to an order which appears to be prejudicial to the interest of the revenue.
my lord. Similar worded,
263 of the IT Act.
my lord.
So the interpretation of that provision by superior courts should apply to a paramateria provision like the 108, because the general power of revision is given under 264 of the IT Act.
True, my lord.
Have you
That
examined
provision,
in your compilation? Do you have this?
yes, my lord. In volume 1, page 88, my lord.
Page 88. Yes, you have that.
Bottom, kindly see, my lord.
Yes,
Revision of orders prejudicial to revenue.
right.
And we have read similarly worded, my lord.
Hmm.
So, my lord, may I read it?
Please read it. We have just read. You can read it again.
The principal commissioner or commissioner may call for and examine the record of any proceeding under this act, and if he considers that the order passed therein by the assessing officer is erroneous insofar as it is prejudicial to the interest of revenue, he may, after giving the assessee an opportunity of being heard and after making or causing to be made such inquiry as he deemed necessary, pass such order thereon as the circumstances of the case justify, including order enhancing or modifying the assessment or cancelling the assessment and directing a fresh assessment. My lord, I will stop for a while here, my lord, and then I will compare the provision of 108. My lord, I will read 263 again and I'll compare with 108. Some of the ingredient of 263 is there in 108, but 108 is wider than 263.
But the limiting condition is prejudicial to the interest of the revenue.
Erroneous and prejudicial to the interest of revenue, this ingredient has been borrowed from 263. I would say so. I will take liberty to say so, my lord. It is very common in all taxing statute, but I would say it is an old statute and it was already there. So possibly the lawmaker might have thought that this is the appropriate words we can pick up from here, which has already settled by 80% of the courts, and it has come to a stage where it requires no further interpretation. That is why the settled words have been carried from here and put into 108. So, my lord, 263 cannot be invoked by anyone else. I will again read, my lord, 263. The principal commissioner or commissioner may call for and examine the record of any proceeding under this act, and if he considers that any order passed therein by the assessing officer is erroneous insofar as it is prejudicial to the interest of revenue, he may, after giving the assessee an opportunity of being heard and after making or causing to be made such inquiry as he deemed necessary, pass such order thereon as the circumstances of the case justify, including an order enhancing or modifying the assessment or assessment. My lord, I will just read now 108, my lord, so that we can understand that some ingredient of 263 is there, but it is broad based. Now 108, subject to the provisions of 121 and any rules made thereunder, the revision authority may, on his own motion, it is parameter to 263 here, or upon information received by him. This is expansion. Or on request from the Commissioner of Central Tax, call for and examine the record of any proceeding. And if he considers, my lord, these are the two parts. One part before and is that how the jurisdiction can be invoked or set in motion. And the second part is that then the power is totally vested in him. If he considers it fit, then only he will revise the order, otherwise he will not. So there is no right vested in me, but of course I can invoke his jurisdiction. And if he considers that any decision or order passed under this act or under Central Goods and Service Tax Act by any officer subordinate to him is erroneous insofar as it is prejudicial to the interest revenue and is illegal or improper or has not taken into account certain material facts, whether available at the time of issuance of the said order or not, or in consequence of an observation by the Comptroller and Auditor General of India, he may, if necessary, stay the operation of such decision or order for such period as it deems fit, and after giving the persons concerned an opportunity of being heard, and after making such a further inquiry as may be necessary, pass such order as he thinks just and proper, and including enhancing, modifying, annulling the said decision or order. Now, my lord, the word information. First is, your lordship, own motion. In particular, my case, he has not exercised the power, though he should have. But I filed application, which was in the nature of information, and that information may be from any source.
Sources of information or sources from which it can come to the knowledge of the revisional authority that there is something to be examined in the record of any proceedings is widened under section 108 with, more clarification. But so far as the condition for exercise is the same as that of 260.
Income tax.
So, if that condition is not met, that means that it is not prejudicial to the interest of revenue, then the revisional authority will not do all the subsequent acts which it is required.
Very correct, my lord. That is why he says, if he considers that any decision or order passed under this act, it is he to exercise that jurisdiction, my lord. It is erroneous and to interest, my lord, prejudicial to the interest of revenue. My lord, Article 265, where I say, the taxes are levied and collected not only for the sake of revenue to the exchequer, but for regulating the economy also.
No, but the point is that if the statute consists of the constitutional prescription under Article 265 has deliberately couched the revisional power in a language which is not general in nature. You see, 264 of the Income Tax Act deals with all other orders which are not under 263. So that is a power where an SSC always invokes that jurisdiction. Either he has missed the appeal or deliberately he invokes the revisional power. But 263 is not invoked by any SSC. He may also give an information, or the information can flow, though explicitly not elaborated in 263. But revisional authority can get information from any sources. He has just to see whether the legality, regularity or propriety of the order is there or not after examining the records. So therefore 108 is a power which is not a broad revisional power, but a provisional power which is to be exercised only in an event where the impugned order or the lower court's order is prejudicial to the interest of revenue and erroneous and illegal or suffering from problem.
Correct, my lord.
So there your case may not fit in.
Well, that I have to make out. My point is that under 108, all and every kind of order under My lord, under
Yes.
108,
Yes.
each and every kind of order cannot be revised.
No.
Only certain orders can be revised.
Yes.
Right, my lord? Not each and every order. Unless the twin conditions laid down under 108 is met, the power cannot be exercised by the authority. One has to make out a case that their order is erroneous and also it is prejudicial to the interest of revenue. As I said, my lord, any order against the SSE will never be prejudicial to the interest of revenue. So it is revenue or revenue administration, my lord. That is the point. The word revenue is not loss of revenue, but it is Article 265.
No,
It is
that,
flowing from Article 265.
are you armed with any particular precedent on this
Yes,
interpretation?
my lord. My lord, my lord, my lord, my lord.
Concerning any
Directly on the
parameter?
point. My lord, directly on the point. Mildly kind of see, my lord, judgment of Supreme Court in the case of Malawar Industrial Volume 2, my lord.
Okay.
Before that, my lord, I would like to take your lordship to judgment of Kerala High Court in Volume 2 itself. That is serial number 8, page 77, my lord. Page 77, Volume 2, my lord.
Yes.
Bismillah Trading Company. Got, my lord?
Yes.
My lord, kindly come to page 87.
At page 80, section 37.
My lord, I am at page 77. That is the case law of.
No, at page 80, the relevant provision is quoted. Power of revision of the Board of Revenue.
My lord, I have already gone through the entire thing, my lord.
No, not gone through. I just.
My lord, should I read that power?
Just for.
Para 10, my lord. Before considering the rival submissions, it is useful to reproduce section 3745A1 and 45A3 and 45A5, section 37. Power of revision of the Board of Revenue, suo motu. The Board of Revenue may suo motu call for and examine any order passed or proceeding recorded under this Act by any officer or authority subordinate to it, other than appellate assistant commissioner, which is, in its opinion, is prejudicial to revenue and may make such inquiry as or cause such inquiry to be made and subject to the provisions of this Act may pass such order thereon as it thinks fit. Subsection 2. The Board of Revenue shall not pass any order under subsection 1 if A. The time for appeal against that order has not expired. B. The order has been made the subject matter of an appeal to the appellate assistant commissioner or the or of a revision in the High Court, or more than 4 years have expired after passing of the order referred to therein. 2A. The notwithstanding anything contained in subsection 2, the Board of Revenue may pass an order under subsection 1 on any point which has not been decided in an appeal or revision referred to in clause B of section 2 before the expiry of period of 1 year from the date of the order in such appeal or revision, or before the expiry of period of 4 years referred to in clause C of that subsection, whichever is later. No order under the section adversely affecting persons shall be passed unless the person has had reasonable opportunity of being heard. So the provision is almost similarly worded.
Yes.
Now kindly have, my lord, page 87,
Yes.
para 24. Second para from top, my lord.
263 has also been quoted at page 85.
Yes, my lord. And that's also interpreted in next page, my lord.
Yes.
My lord, page 87, para 24, second para from top. In our opinion, the word prejudice must be judicially examined. What constitutes prejudice to revenue has been subject matter of a judicial debate. One view was that prejudicial to the interest of the revenue does not necessarily mean loss of revenue. The same line has been held by the Supreme Court in the case of Malawar, that I will come take your lordship to just now after this judgment, my lord. The expression prejudicial to interest of revenue is not to be construed as in a pettifogging manner, but must be given a dignified construction. The interest of revenue are not to be quoted to rupees and pies merely. There must be some grievous error in the order passed by the ITO which might set a bad trend or pattern for similar assessment, which, on a broad reckoning, the commissioner might think to be prejudicial to the revenue administration. The prejudice must be prejudice to the revenue administration.
Yes.
Now, kindly see, my lord, the next judgment, Supreme Court in the case of Malabar Industrial, page 69, my lord.
Yes. At page 25, Malabar has been referred to by this Kerala judgment.
Yes, my lord.
Para 25.
Just thereafter, my lord.
Yes.
My lord, I will, should I read from here or the judgment itself, my lord?
Let us read it in continuity so that the opinion of the Kerala High Court.
My lord. The judgment is rendered by the Kerala High Court in Malabar Industrial Company Limited was taken on appeal by unsuccessful accessory by special leave. The judgment of the Supreme Court is reported in JT so and so. Supreme Court, after considering section 2631, has in paragraph 6 and 7 of the judgment observed as follows. A bare reading of this provision makes it clear that the prerequisites to exercise of jurisdiction by Commissioner Sumoto under it is that the order of the income tax officer is erroneous insofar as it is prejudicial to the interest of revenue. The commissioner has to satisfy of two conditions, namely, the order of the assessing officer sought to revise is erroneous, and two, it is prejudicial to the interest of revenue. If one of the I think something missing is absent. If the order of the income tax officer is erroneous but is not prejudicial to the revenue, or if it is not erroneous but prejudicial to interest to the revenue, recourse cannot be had to section 263 of the Act. There can be no doubt that provision cannot be invoked to correct each and every type of mistake or error committed by the assessing officer. It is only when an order is erroneous that the section will be attracted. An incorrect assumption of fact or an incorrect application of law will satisfy the requirement of the order being erroneous. In the same category fall orders passed without applying the principles of natural justice or without application of mind. The Supreme Court also, next para, my lord, referred to judgment of the High Court of Calcutta in Dauji Dadaboy, so-and-so, reported High Court of Karnataka in Commissioner of Income Tax versus T. Narayana Pai, High Court of Bombay, and the High Court of Gujarat, which considered the words prejudicial to interest of revenue. All the four High Courts treated loss of tax as prejudicial to interest of revenue. My lord, I am reading again. All the four High Courts treated loss of tax as prejudicial to the interest of revenue. The judgment of Madras High Court reported in Venkata Krishna Rice Company, so-and-so, which was also not accepted as correct by this court, was also cited before Supreme Court. Supreme Court in paragraph 9 has observed that in their view, the interpretation given by the Madras High Court is too narrow to merit acceptance. Explaining further, Supreme Court has observed in para 10 as follows. The phrase prejudicial of interest revenue has to be read in conjunction with erroneous order passed by the assessing officer. Every loss of revenue as a consequence of an order of assessing officer cannot be treated as prejudicial to interest of revenue. For example, when an income tax officer had adopted one of the courses permissible in law and it has resulted in loss of revenue, or where two views are possible and the income tax officer has taken one view with which the commissioner does not agree, it cannot be treated as an erroneous order prejudicial to the interest of revenue unless the view taken by the income officer is unsustainable in law. It has been held by this court that where a sum is not earned by a person is assessed as income in his hand on his so offering, the order passed by the sitting officer accepting the same as such will be erroneous and prejudicial to the interest of revenue. Applying the principle laid down by the Honorable Apex Court in JT so and so, the case on hand, the following factual and legal proposition would emerge. The Supreme Court held that the commissioner has to be satisfied of two conditions before invoking 263. The order of a sitting officer sought to revise is erroneous, and two, it is prejudicial to the interest revenue, and if one of them is absent, the court had 263 of the Act. In our opinion, the order of the Deputy Commissioner, the Revision Authority, under Exhibit P4, sought to be revised under Exhibit P5 is not erroneous in any manner, and it is also not prejudicial to the interest revenue. The Revision Authority under Exhibit P4, after considering the argument of their either side and after pursuing the record and considering the whole fact or circumstance of the case, set aside the penalty imposed under Exhibit P2 and has also directed the intelligence officer to verify the books of accounts and allow the revision petitioner an opportunity to explain the seized records. It was further directed that the revision petition shall also be given a reasonable opportunity. Revisional petitioner shall also be given a reasonable opportunity of being heard before passing a final order in this case. My lord, I will skip to the rest of the judgment. I will come to judgment Supreme Court in Malabar, my lord, if your lordship permits.
No, you have missed an important line in the continuing paragraph. You read this in our opinion. In our opinion, prejudicial to the interest of the revenue must mean, on the same page, 5-6 lines from the bottom.
May I know what page number?
Page 88 of the same volume.
Yes.
In our opinion, my lord. In our opinion, prejudicial to the interest of revenue must mean that the orders under consideration are such as not in accordance with law, in consequence whereof the lawful revenue due to the state has not been realized and or cannot be realized. It is not the case of the revenue that the revenue due to the suit cannot be realized because of the remittal order made by the Deputy Commissioner, though it is stated in paragraph 5 that the appellant was given ample opportunity of being heard in person and also to file objections to the proposed penalty. He has not availed of it. This statement is factually incorrect, as could be seen from the proceedings as referred in paragraph supra. As pointed out by the Honorable Supreme Court, the provision can be invoked only when an order is erroneous. We have already referred to judgment of Calcutta High Court, Karnataka High Court, Bombay High Court, and Gujarat High Court, which stated loss of tax as prejudicial to interest of revenue, to the interest of the revenue. It is not the case of the learned government leader that there is loss of tax to the state. By the order passed by the Deputy Commissioner, the matter has only been remitted to the original authority and the collection of tax is postponed to a later date. We are of the opinion that there is no grievous error in the order passed by the Deputy Commissioner in Exhibit P4. In our opinion, there was no material before the Commissioner of Commercial Taxes to justify his notice under the order. Notice that the order passed in Exhibit P4 was erroneous and it was prejudicial to the interest of revenue. So that is there, my lord. So, my lord, my submission is
the only distinguishing feature so far as this case of Kerala High Court is concerned is that the proceedings did not originate from any information supplied by the SSC. It was the notice issued upon the SSC in exercise of that revisional power that was the subject matter of challenge. And there the question arose as to whether the twin conditions, erroneous and prejudicial to the interest of revenue, have been met by the authority issuing notice, or is there anything wrong in it? So there these observations have been made. You are trying to invoke Section 108 at your behest and complaining that the expression prejudicial to the interest of revenue doesn't only mean loss of tax,
Correct.
but any revenue which cannot be realized in accordance with law as per 265.
Correct, my lord. Correct, my lord.
So
My lord.
let us see Malabar,
My-
what does it say?
My lord. What other distinguishing feature of
Yes.
this judgment, particularly peculiar to this judgment, is that in this case there was no loss of revenue also. There was no loss of revenue also. The court has indicated that thing. But before indicating that, the court under para 24 clearly said that prejudicial to the interest of revenue is not only loss of revenue, but something prejudicial to the interest of revenue administration. Para 24, my lord, I will read again.
Yes, yes.
In our page 87, my lord, in our opinion, the word prejudice must be judicially examined. What constitutes prejudice has been subject matter of judicial debate. In one view was that prejudicial to the interest of revenue does not necessarily mean loss of revenue. The expression prejudicial to interest of revenue is not to be construed as a pettifogging manner, in a pettifogging manner, but must be given a dignified construction. The interest of revenue are not to be equated to rupees and pies merely. There must be some grievous error in the order passed by the ITO, which might set a bad trend or pattern for similar assessment, which on a broad reckoning, the commissioner might think to be prejudicial to the revenue administration. The prejudice must be the prejudice must be the prejudice to the revenue administration. So that is the understanding.
On the
But
facts,
when
say, just for a discussion, on the facts of any of your particular cases on board today, you would argue that the commissioner or whosoever is the revisional authority should not simply refuse to examine the records on the presumption that it is not a loss of tax to the revenue. It should examine whether the assessment orders are of such a nature which may have a grievous error and which might also send a bad precedent or a trend for similar assessments.
well,
Whether
the
it,
threshold,
whether it ultimately ends in a favorable order in your favor is not the concern of the revisional authority.
correct,
If something has been brought to his notice, let him apply his mind and see whether this order is not confined only to the loss of revenue concept of a prejudicial expression, but whether the order otherwise suffers from such grievous error, which in a larger perspective would be treated as prejudicial to the interest of revenue. If a assessing authority keeps on passing a order which is not in consonance with law, then it obviously also would not be leading to a result which is in consonance with 265 of the Constitution.
my lord, because he is a supervisory authority. Because he is supervisory authority exercising supervisory jurisdiction over subordinate. It is his duty. But the thing is that I cannot claim it as a matter of right. That is the only distinction between 107 and 108. 107 is my substantive right. 108 only I can set his jurisdiction into motion. Then he will consider and he will see whether the twin conditions stand satisfied or not. If the twin conditions stand satisfied, then he will revise the order.
Very
Then
good.
kindly see, my lord, the Malabar Industrial, that is celebrated judgment on this terminology, erroneous and prejudicial to the interest of revenue. Page 69, my lord.
Yes.
The relevant portions, my lord, are on page 73. The bottom para, my lord, the section 263 of the Income Tax Act is quoted, my lord.
Yes.
I am skipping that particular portion, my lord. We have already read.
Yes.
Coming to page 75 of 4, my lord, para 6.
Yes.
Para 6. A bare reading of this provision makes it clear that the prerequisites to exercise of jurisdiction by the Commissioner Shumoto under it is that the order of the income tax officer is erroneous insofar as it is prejudicial to the interest of revenue. The Commissioner has to be satisfied of two conditions, namely that the order of the assessing officer sought to be revised is erroneous and it is prejudicial to the interest of revenue. If one of them is absent, if the order of the income tax officer is erroneous but is not prejudicial to the revenue, or if it is not erroneous but is prejudicial to the revenue, recourse cannot be had to section 263(1) of the Act. Then 7 is very important, my lord. There can be no doubt that the provision cannot be invoked to correct each and every type of mistake or error committed by the assessing officer. It is only when an order is erroneous that the section will be attracted. An incorrect assumption of fact or an incorrect application of law will satisfy the requirement of the order being erroneous. In the same category fall orders passed without applying the principles of natural justice or without application of mind. The phrase prejudicial to interest revenue is not an expression of art and is not defined in the Act. Understood in its ordinary meaning, it is of wide import and is not confined to loss of tax. So, my lord, what I am submitting
Yes.
that Article 265, all the provisions of the Act has to be read in the context of Article 265. If we say that the prejudicial to interest revenue is only loss of tax or loss of revenue money to the government, then it will be the whole Article 265 because a wrong order passed against which no appeal is filed. Now, particularly, my lord, when there is a onerous condition of pre-deposit under 107, this provision assumes more importance. 108. A person may not be in a position to pay the pre-deposit. Now, I am putting it the other way around. Department will argue that when there is provision 107, then they cannot avail the remedy under 108. I am putting it the other way. When the statute, when the legislature made an onerous condition of pre-deposit under 107, section 108 assumes more importance. There may be persons who are not in a position to pay any amount of pre-deposit, but the order is erroneous and prejudicial to the interest of revenue.
Yes.
Then 108 can be invoked or brought to the notice of the supervising authority that kindly see that this order is erroneous and also prejudicial to the interest of revenue. It can be brought to his notice and he can exercise his power. So when there is a wrong, there is a remedy. If we confine the remedy only to 107, then there may be some persons who may not avail 107 remedy, and that is why 108 says that he should not have availed the appellate remedy. That itself shows that the two remedies runs in the parallel. One, I have a right, in another I don't have a right, but still I can invoke the authority and say that, see, the orders passed by your subordinate are not in accordance with law. So kindly revise it. And if that is done, ultimately it has to meet the goal of set by 265, Article 265. If that is done, then the purpose of the 108 and Article 265 will be met, ultimately. Now, my lord, coming to the word information. Information by me can set in motion 108 or not. My lord, kindly have judgment Supreme Court in the case of Larsen Toubro, page 53, my lord. Page 53, judgment starts, Larsen Toubro Limited, State of Jharkhand. And my lord, the relevant portions are on page 62. Page 62, my lord, the bottom portion, para 26, my lord. It is also pertinent to understand the meaning of the word information in its true sense. According to Oxford Dictionary, information means fact told, heard, or discovered about somebody, something. The law lexicon describes the term information as the act or process of informing, communication, or reception of knowledge. The expression information means instruction or knowledge derived from an external source. My lord, kindly underline these words, from an external source, concerning the facts or parties, or as to law relating to and or having a bearing on the assessment. We agree that a mere change of opinion or having second thought about it by the competent authority on the same set of facts and material on the record does not constitute information for the purpose of the State Act. My lord, just I'll pause for a while here. Just for a while, my lord. The
Yes.
court is trying to separate the chaff from the grain, saying that change of opinion is not information. Information which has already been acquired will not be for fresh information. But information which is brought to his knowledge for the first time is information. But the word information used in the aforesaid section is of widest amplitude and should not be construed narrowly. It comprehends not only variety of factors including information from external sources of any kind, but also discovery of new fact or information available in the record of assessment not previously noticed or investigated. Suppose a mistake in the original order of assessment is not discovered by the assessing officer. On further scrutiny, it came to the notice of another assessor, and even by a subordinate or superior officer. It would be considered as information disclosed to the incumbent officer. If the mistake itself is not extraneous on to the record and the information gathered, the information from the record, the immediate source of information to the officer in such circumstances is one in one sense extraneous to the record. My lord, why I said pause and said that thing? What is trying to say that the information which was already in the knowledge of the assessing officer in the original assessment, if he uses the same information for reopening assessment, that will be change of opinion. So it is saying that information already acquired by him while passing the original assessment order, second time harping on the same will be an extraneous thing, and that will not come under the meaning of the word information. Only fresh information and information within the meaning of.
Acha, in all these repetitions, in none of them the CGST is involved, the central government.
No, Lutz. It's only the state government.
So, Mr. Parti, you have been appearing for the CGST, obviously, in many cases. What is the understanding of Section 108 so far as the CGST authorities are concerned?
Well, there so far now no case has come up, my lord. But my understanding, my lord, the argument being advanced that in capacity to make the pre-deposit will give him a right to prefer a revision. That is not correct, my lord. Pre-deposit condition has been challenged in several cases and in different statutes, and the Honorable Supreme Court has consistently held that yes, pre-deposit, if it is mandatory, it has to be done, and such conditions are valid. So the power of revision will be limited in those cases, my lord, which are given in the section itself, not on the ground that he is his inability to make the pre-deposit. And certainly the revisional power is less than the appellate power, and in those limited cases.
No, definitely, but whether the revisional authority understands the expression prejudicial to the interest of the revenue in a narrow, pedantic, myopic view that it would only take into its compass cases where there is loss of tax to the revenue, or it means where an erroneous order which ultimately allowed to survive would also be to the interest of revenue for other reasons, as it is not in consonance with law.
Lord, it has to be as decided by the Honorable Supreme Court. In that sense, it has to be understood.
In that case, the limiting conditions under section 2 of section 108 would be the conditions in which the revision power may not be exercised pending appeal or pending expiry, or if the period of the 3 years has expired after the passing of the order and the information has been brought to the notice of the revisional authority. On facts, whether in all these cases, whether the period of the filing appeal had expired.
Yes, yes,
Yes,
yes.
in all cases, my lord. Orders have been passed, my lord. Impending orders are of the year 2018. And if you lordship permit me, my lord, though it is very interesting issue, my lord, it cannot be argued at threshold. But, my lord, what I have understood, my lord, two preconditions are there, my lord. For, my lord, application, for, my lord, availing the benefit of section 108. Your lordship will see, my lord, section 108, it is not like, my lord, an ordinary, my lord, provision of revision, my lord, like other statutes, my lord. Here, some exceptions are there, like, my lord, subsection 1, my lord,
2011-2018.
Mr. Prasad, kindly mute yourself.
So,
I'm sorry.
some my lord, distinctive features are there, my lord, in section 108, unlike, my lord, the other my lord, provisions in other statutes, my lord, that I will come later on. But, my lord, so far the my lord, subsection 1 is concerned, two my lord, preconditions are there. Number one, your lordship has seen, my lord, erroneous application of mine, or my lord, non-application of mine, or violation of principles of natural justice. Second, my lord, at both conditions must, my lord, coexist for, my lord, availing the benefit of section 108. Second condition is, my lord, the order must be prejudicial to the interest of the revenue. What your lordship is asking, whether, my lord, the department is taking at, my lord, limiting to loss of revenue only, in my humble submission, no, my lord, it can't be. It can't be, my lord. The Honorable Supreme Court has laid down, and that, my lord, judgment is of binding, and we accept, my lord, that so far loss of revenue is concerned, my lord, it is one part, but so far, my lord, the administration of revenue, Department of Revenue, my lord, the revenue matters, that is, my lord, the wider aspect of the matter. But both the conditions, my lord, must coexist. Otherwise, my lord, it cannot be, my lord, revision it cannot be maintained. Now, here the issue, what has fallen from your lordship's mouth, what my learned friend has argued, my lord, I can distinguish, my lord, both the judgments on fact that these judgments are not applicable. If your lordship permit me, my lord, one of the judgment which my learned friend was referring, my lord,
Mr.
that is
Sachin,
Kerala High Court judgment.
Mr. Kurmi has not concluded.
Yes, he has not concluded, my lord.
We had posed a question because how does the central authority treat this provision? You see, there is one thing that at the threshold, a revisional authority would say that no, I cannot treat your information as for reopening or exercising my revisional power, as you have an appellate remedy, and to my mind, it doesn't amount to prejudicial to the interest of the revenue, no revenue loss of tax. It is something against you, and that cannot be against the revenue. The other thing, that instead of exercising that, relegating the person to section 107 at the threshold, the revisional authority examines it in its own records, that yes, whether the order is erroneous and it affects the administration of revenue in the larger sense, and then says that no, I do not require to interfere in it. You have, if any grievance, you have a remedy of appeal where you have to make a pre-deposit, and all issues of fact or issues of law are open for you to converse. For my purposes, I do not treat it as something which is prejudicial to the interest of revenue, coupled with the fact that the order is erroneous also. So, whether the revisional authority in these cases has relegated them at the threshold itself without any examining of the records?
Without
Yes.
examining the record.
Yes, my lord.
Yes, yes.
Without examining the record. and my lord, subject to what will be further argued, but
Now-
whatever is coming through.
In that case, on the given facts of individual writ petitions, and this is to both the sides, if an interpretation which is being sought for is clearly declared or pronounced by us, is it necessary for the petitioner to satisfy us that yes, these two conditions are actually being met in my case, and still the revisional authority has refused to entertain it?
My lord, in my humble submission, my lord,
So, if on the facts these two ingredients are met, then we may be called upon to say that the revisional authority should have applied its mind and said that yes, it is not prejudicial to the interest of revenue and erroneous. Otherwise, without applying our mind to the twin conditions, if we say so, then we would be laying down a law which the SSCs would invoke and straight away go to the revisional authority, saying that each and every case we give you an information, apply your mind, and then say these two conditions are not met.
and your lordship has correctly pointed out, my lord, because the authority concerned has not decided these issues, my lord. So, deciding, my lord, at this stage, whether it is prejudicial or erroneous or not, these are required to be, my lord, seen. Now, your lordship has to only see whether 108, the petitioner could have invoked section 108 or not, and whether the petition filed by the petitioner could be, my lord, will come within the purview of information as envisaged under section 100. In my humble submission, that would be enough, my lord. And leaving, if your lordship comes to the conclusion, finally, if this is the view of the court, my lord, that the petitioner can invoke, my lord, the divisional jurisdiction, then rest things are required to be decided by the authority concerned first. Whether erroneous or whether, my lord, it is prejudicial.
So
when Mr. Pati will also agree with me.
in effect,
Yes, my lord. In that case, in every case, what will happen? They will file a revision and come back saying that the authority should hear me. Not in this case, but in general, that will start happening, and the revisional authority will then have to hear it.
in effect, making a declaration on an academic position without examining whether the case of the petitioners actually fit in those two conditions of section 108 would lead to a general declaration of law, which may ultimately lead to consequences not envisaged. That every SSC bypassing appellate remedy and going before the revenue revisional authority, and he being compelled to apply its mind and speak on every such application or information. So that makes our task onerous to examine at least in each individual case
Yes.
whether the two conditions are met or not. Mr. Kurmi, you have heard our
My lord.
thinking aloud.
My lord.
In fact, the line of, my lord, the argument which are coming from lordship's side, my lord, that in my humble submission, my lord, that is on that your lordships are required to be addressed. These judgments, my lord, may be, my lord, distinguished on facts.
My lord, my humble submission would be that when there are two provisions made by the legislature, 107 and 108, the legislature was aware that it is inserting 108 after 107. And legislature, there is a presumption against redundancy. Legislature never wastes words. It has wasted a page. If the understanding of revenue is accepted, then it wasted a page. That's why, my lord, I started with Article 265. I say a particular person has not filed appeal. Either he will like to go by the appellate route or he will like to invoke the jurisdiction of the authority. Authority may say, I am not finding anything. The two ingredients are not there. I cannot, I'm helpless. Go for appellate remedy. He will go to appellate remedy, my lord. There is no reason in not going to that. Otherwise, he will be remediless. But if the twin conditions are satisfied, twin conditions are the limiting factors. It is not that in each and every case, 108 can be invoked. Only in those cases where there is a likely contravention of Article 265, or the state may retain tax which is not due to it. 108 can be invoked in either of the three ways. One, by suo motu himself, or on the basis of any information received. That information may be by the HSC itself, or at the instance of the Commissioner of GST or Central or State Taxes. So, my lord, there is nothing in this 108 to limit the scope of 108 to only to the suo motu revision. What the department understanding that it is suo motu revision, your information cannot be information, you cannot supply information to us. It may be an external information from any external source. That is what Supreme Court has said. I am laying emphasis on that only. I am saying that information, one cannot say that barring the HSC information, all information are acceptable, and information given by the HSC is not acceptable. It cannot be read in such a narrow way. The word information has been read by Supreme Court, and Supreme Court has said any information, whether even unauthorized one, even if I am not authorized to file an application before the authority, even I am not authorized or having right to invoke the 108, I am not authorized to do so. Even then, by any information given by me will be sufficient to invoke 108. That word unauthorized has come. So, my lord, I was reading page 63. If I might conclude, my lord. Page 63, my lord. First para I was reading, my lord. I was on the fifth line from the bottom on the first para. It will be information. Page 63, my lord. First para, my lord.
Yes.
Page 63, fifth line from the bottom. It will be information. It will be information in its position within the meaning of section 19 of the State Act. In such cases of obvious mistake on the face of the record, the record itself can be a source of information. If that information leads to a discovery or belief that there has been an escape of assessment or under-assessment or wrong assessment, then my lord, kindly come to page 65. Page 65, my lord, para 31. Para 31, my lord. The contention whether the information from the very fact that were already available on record amounts to information for the purpose of section 19 of the Act, it would be sufficient to refer to judgment of this court in Anand G. Haridas and Company Private Limited versus SP Kasture, wherein it was held that a fact which was already there in record does not, by its mere availability, become an item of information till the time it has been brought to the notice of the assessing authority. Hence, the audit objection were well within the parameters of being construed as information for the purpose of section 19 of the State Act. The issue before the court was that whether the audit officer can bring certain information to the knowledge of the officer or not, revision authority or not, which were already in the record. The court held there being information in the record does not mean it's not information unless it's brought to his notice. That is what I am doing here.
So, Mr. Kurmi, you are in 226 jurisdiction, and unless the court is satisfied, in your case, injustice has resulted on appreciation of the individual case of the petitioner. We may simply say that your case doesn't require any pronouncement on the legality of the impugned order, because you have not been able to show to the court that these two conditions were actually satisfied in your case. So, therefore, that inquiry by us, although a burdensome inquiry, will have to be gone into, because we may simply say that he has not made out a case as to why the revisional authority had committed some wrong. If he first makes out a case that it is an erroneous and both prejudicial to the interest of revenue, then only we say that yes, the revisional authority should have examined it and seen whether it is these two twin conditions are satisfied or not.
My lord, your lordship would kindly see.
That brings us to how many cases totally before us? 18 to.
My lord, the case I'm arguing, that's the item number, lordship.
It's altogether 12 cases are there on board today.
My lord, in item number that I'm arguing, your lordship, item number 25.
Just a minute, just. Yes, Mr. Pati. Sorry, Mr. Kulmi. Sorry.
My lord, in item 25, which is the lead matter, I would submit pray your lordship to kindly see page 129 what he has done. He has written my result of my application. He has not delved into it. He has not applied his mind.
No, that is true. That is true. That we have seen. That we have seen.
Simply he has returned. So my point is that when information is brought to his knowledge, then the ingredients of 108 should have been examined. And after considering whether the ingredient exists in the case or not, the application should have been rejected. It is not that it is not maintainable. Page 129 kindly see, my lord.
No, that we have seen. That we see. But we consider, or we are prima facie thinking aloud, that each of the writ petitioners need to demonstrate to us that he had a case under section 108 which the revisional authority has not entertained because of total non-application. A blanket window we may not like to open, as any other person, any other aggrieved SSC would straight away say that yes, you are compelled to. We will not pronounce our opinion on that, but the writ petitioner is required to satisfy on his own case as to how the order is erroneous and how it is prejudicial to the interest of revenue in that broader sense, which the revisional authority ought to have examined. Perhaps today your preparation in other connected matters on the individual facts may not be enough or may not be ready.
My lord.
So, a summary on individual cases would help, And in the meantime, we will also ask Mr. Pati, who represents CGST, to find out from CGST authorities as to how they treat Section 108.
Some order is kindly indicated, then it will help me, my lord.
We will say that you
Yes,
generally appear for CGST also, you may seek instruction as to the
Yes, my lord.
so that is the position that we come to upon hearing you today.
तो लेके आओ एक बार इसको सारा इंडिया फॉर्म लेके आओ, पीएलटीस लेके आओ सारा इंडिया फॉर्म।
we'll keep it on 28th. 28th February, 28 February.
Yes, my lord. That's all right.
On individual writ petitions, a short summary of 2 pages, which shows your point on both these, shows your case on both these points under section 108. And in all these cases, the order of impugned order of the same 4 lines only.
Yes, my lords, in all the cases.
And the state councils, have you also given some decisions or any short notes for our?
No, my lord. Still not, but we will send it, my lord.
So send it. And Mr. Pati, you seek instruction also informally. Arguments have been advanced by learned counsel for the petitioner, Mr. Karthik Kurmi, on the interpretation of section 108 vis-a-vis section 107 of the GST Act. Which is the common issue arising in all these writ petitions. Legal issue. Stop. And counsel for the petitioners submit that the supplying a short synopsis of the case of individual writ petitioners. Stop. And counsel for the respondents are also at liberty to do so. Submit their written notes. And decisions on which they seek to rely. Stop. Mr. Pati, you informally seek instruction, we will not indicate in the order. Take a view from them. Let the matter appear on 28th. Let these matters appear on 28th February 2022. Stop. Written notes, if any, be supplied latest by 25th February 2022. The court master.
Sunday or 28th.
28th is Monday.
My lord.
And what you can do, Mr. Kurmi,
My lord.
the extracts of these 2-3 decisions.
I will do, my lord.
That should be incorporated in the written notes of one of them.
My lord.
So your proposition both on interpretation of information source, then prejudicial to the interest of revenue, these things come straight away from the judge.
My lord, that I will do, my lord. I have been doing, my lord, but this time I got some little time, my lord. I did not got sufficient time, otherwise I would have been doing it, my lord. I will send it, my lord.
Very good. So, list over. So we conclude.
Pranam, Lordship.
Good afternoon, sister.
Good afternoon, Lordship.
Small matter.
Yes. I was giving dictation in the. I got
no.
late 2 minutes. Yes.
Contrary.
On the supplementary for the for orders to defect item 1, safety number 149 of 2021, Mr. Sresh Gautam. Order to defect.
Mr. Gautam, there is a defect, no? No. So we give 1 week time to remove the defect.
Yes, sir.
1 week time is allowed to learn counsel for the petitioner to remove the surviving defects as under office to close the file. If defects are removed, matter will be listed as and when the bench is constituted or on being mentioned as and when the bench is constituted. That's all, sister. Yesterday this matter was there, the connected matter. They said that they have not been able to get it listed. Then we said you mention and we'll list it.
That's right. No issue.
Okay, sister. We have another bench just after.
Okay. Pranam.
Mr. Gautam? Anyone? Mr. Sresh Gautam, you are on screen.
Am I audible?
Ah,
Yes, Your Lordship. There was some network issue, Your Lordship. I apologize, Your Lordship.
we have given you 1 week time to remove 2 defects and
Yes, Your Lordship. Lordship, as per my understanding, there is only one surviving defect with regards to cause of action, Your Lordship.
whatever it is, that will be indicated in today's order. You remove
Yes,
it.
Your Lordship.
Very well.
This CMP is allowed, Your Lordship.
No. Defect only after defect removal that will be.
Yes, Your Lordship. I'll do that, Your Lordship.
After you remove it within 1 week, then you mention as and when the bench is constituted, we will take it up.
Yes, Your Lordship. I'll do that.
So,
Obliged, Your Lordship.
brother has joined. Good afternoon, brother.
Good afternoon. Good afternoon.
Yes.
Good afternoon, my lord.
Under heading for hearing, item 1 for particular location behind of
And
Both the councillors are present for the rival parties.
yes, my lord, I am for the appellant in the matter.
And I am for the mother, my lord, respondent.
My lord, two development that has taken place in the late hours of 4th, that is on at 11 p.m. we received a mail from mother that the to and fro cost for Calcutta journey that was asked, and for 11th that she will be carrying the child. So we have credited that amount, my dear, to the mother's account. That was done on the probably 6th. 4th, we received late night, we received the message email that we could not bring on record, but that is the one development that has taken after I mentioned the matter, my lord.
So, the IA which you mentioned with an apprehension,
Yes.
that
No,
that is taken care of. The mother has.
It seems, my lord, because past experience say, my lord, because one RT-PCR test has to be done as per school before carrying the child to taking the child to Calcutta, from where this.
No, the learned counsel for the mother obviously will affirm that the mother is ready to accompany the child if she wants to go to Uti to drop her at the school.
No, she has taken escort services from Calcutta, my lord. She has asked for Calcutta ticket.
Oh, up to Calcutta only she wants.
So she has asked.
She will hand over the child to the escort party, my lord, of the school, and they will take the child by air to Coimbatore and
Obviously.
school.
That's very good. Let the child resume studies. Our children are also in our homes. We are waiting for the schools to be open to send them to school and university.
Yes, my lord.
My daughter was saying, my lord, that now we are fed up. We were earlier asking for holiday, now we don't want. Every day for their.
Actually, they had the worst time. The children had the worst time compared to all others.
Yes, my lord.
The elder people have so many means to go out, and for some or the other reason they can go out, and they naturally have so many responsibilities. The children have been confined for 2 years, and it has affected their mental. It has affected their mental state. They have become irritable. They don't listen to the parents. There is no peer group.
Yes, my lord. She was unwilling to go, my lord, but anyhow the mother arranged to convince her, and now the mother is ready to prepare to take the child on 10th, my lord, to Calcutta to hand over to escort, my lord.
Very well. So we will record a short order today.
One more thing, my lord. RT-PCR test has to be done before taking the child to Calcutta. That may be recorded, my lord.
Very well. Brother, a short order on their affirmation that the child is.
Yes, it seems good.
One more thing, can I pray? One more thing, my lord. Subject, my lord, my father has come. Can he join, my lord? He is there.
Let him join this. No?
Yes, my father. Every time he comes, this is the 4th visit to take his child to Coimbatore from Bangalore. Today morning flight he has taken at 5.
God bless the parents and the child.
One thing that we were submitting, my lord, if some kind, because every year, my lord, there is twice at least the child has to be taken to
Now she is in which class?
She is in 7th. 8th. One more thing, my lord, there is a subject choice, my lord, that I had agitated on last occasion. My lord, the mother had given her own view without consulting me. That may be said, my lord, that school being expert may take a call on the point. If so required, school may consult the parent or may take view. Because we have enclosed all the results, my lord, in our affidavit. So,
have you filed any affidavit or IA regarding?
I have filed one affidavit, my lord, on 3rd of December 2021, my lord. That was taken note of on last occasion, my lord, when order was passed.
Okay. देखिए, Mr. Prashant Pallav for the appellant father and Mr. Shakal Dev Singh for the respondent mother. For the mother, appellant mat likhiyega, for the father and mother respectively are present. Today the case has been taken up on being mentioned by learned counsel for the father on IA number 692 of 2022. So, the schools, the students have been asked to join this so-and-so Good Shepherd School Uti on 11th of February 2022. Pursuant to the guidelines notified by the
State of Tamil Nadu, my lord.
State of Tamil Nadu contained in notification dated 28 January 2022. Stop. The relevant extract thereof is quoted here under. ये पेज 10 आईए का जो है इसमें पेंसिल से मार्क कर दिए उसको. Stop. For that purpose, all children, all students, including Aditi Vishakha, have to report to the school. Thus, have to report to the school on 11th February 2022. Stop. She has to undertake travel from Jamshedpur to Calcutta and accompanied by her mother and on her request, and thereafter with escort staff from Calcutta to Coimbatore by flight. Stop. Tickets have been arranged. Stop. The apprehension of the father as to some hiccup in the movement of the child is does not exist, as on the request of the mother, the expenses for her to and fro journey from Jamshedpur to Kolkata have already been credited in her favor. Stop. The girl has to carry a RT-PCR report, which the mother would do. Mother would ensure. Stop. The girl has undertaken the first vaccination on 18th January 2022. Stop. As per the statement of the appellant father in the instant IA, the second dose would be administered in the school itself, for which necessary arrangements would be made. Stop. These statements are being recorded on categorical affirmation on the part of learned counsel representing the parties. Stop. Appellant has also joined from the office of his father has also joined from the office of his counsel, learned counsel. Stop. One more aspect has been brought to the court's notice regarding the choosing of a particular discipline from the which class, 9th or 8th?
9, 10, my lord, but 8th it has to be communicated to ICSE.
For the ensuing higher classes 9th and 10th. Learned counsel for the father submits that the child has exercised an option, perhaps at the instance of the mother, to choose the commerce stream.
Arts, my lord.
Arts stream.
No, my lord, the
No, it's
child,
the mother who has exercised.
mother has represented the will of the child, my lord, in matter of study, my lord. Because the mother cannot ignore the wish of the child, my lord.
The
Because
mother
the child
has,
expressed her view to study those subjects, so mother has represented, my lord.
the mother has exercised the option for the child to opt to choose the arts stream. Stop. Through
Without consulting the
supplementary,
father, my lord, that is one thing we want.
through a supplementary affidavit filed on
Which is filed on, my lord, 3rd of December 21. Relevant would be para 13, my lord. 3rd December 21.
3rd December. देख लीजिए affidavit का date अलग होगा, filing का अलग होगा. Through an
Para
affidavit
13 would be relevant, my lord.
filed by the father on 3rd December 2021, he has conveyed that the option should have been exercised after consultation with him, since as per the progress reports, the child has been doing very well in the science stream. Stop. During course of submission today, learned counsel for the appellant submits that the issue of choosing a particular stream may be left for the school authorities to decide after consultation with both the parents and considering the progress report and mm, progress report and aptitude of the child for a particular stream. Stop. Learn Council for the respondent submits that the option has been exercised by the mother after at the instance of the child. Stop. Para. It appears from submission of Learned Council for the parties that this option has to be exercised and reported to the which board?
ICSE board, madam.
ICSE board while the student is in class 8, which Aditi Vishakha is presently studying in. Stop. Since it's a career option, Since it's a career option, and an informed decision needs to be taken in that regard, considering the past results of the child indicating her predilection to a particular discipline. However, the school authorities, since this court is exercising parents' patriarch jurisdiction, we deem it proper to entrust this responsibility upon the school authorities, who are the best judge, but of course, after taking into account the past performance of the child, her predilection to a particular stream, and also on consultation with both the parents. Stop. Needless to say, the journey to the school back on 11 February 2022, which of course is after an interregnum of about 2 years of online teaching, should be a smooth affair, and both the father and the mother should cooperate in the process. Stop. We wish the child all success in her present class and also in her future studies. Stop. Interlocutory application number 214-692 of that takes care of everything.
My lord, actually only one thing which your father wants to submit, if allowed, my lord.
No, nothing
He's-
remains of any submission.
Then we are making submission to my lord. My lord is exercising parents.
Yes.
And for every time we have to come to get the child to the school. So some general kind of order, if can be passed, that parents should stick to the calendar, school calendar, and undertaking given.
You see, these
The order is already existing, my lord, to send the child. There is no need of any fresh order, my lord.
that several orders have been passed earlier. In fact, I was going through the past orders right from 2016. And last order was perhaps 22nd August 2019 and 20 July 2019.
23rd July, my lord.
Then also some arrangement was made at the
Yes. Then my lord, again January, I was taken. There was cases after cases in airport. All that has happened. We don't want to, because there is a wonderful development in this period, and father is really happy about it. but we cannot spill in we want to bring that fact in seal cover. That's the thing. That has given a lot of sense of satisfaction to father, my lord. But I cannot bring it in the domain to just create further hiccup. But what he had lost, the affection of the child, he is getting that. That document will reveal, my lord. And whenever my lord will hear this matter, I will just seek leave of the court to bring that document on record for, because it is all the effort of my lord. And we are really grateful that even after 1:30, that is purely my lord's time, not the court's time. And you have, my lord has again taken the pain to.
No, it's all the blessings of the Almighty. We are only doing our work.
Father wants to say something.
Since this is a special bench and obviously the matter is taken up after a long time, if he wants to say a few words.
Yes, he wants to say something.
Lordship, first of all, I am indebted to this honorable court and to your Lordship because there is a tremendous change in the future and career of this girl. You have saved one girl child, and I am a very helpless father because I can do a lot of things to her, but I can only do when there is a parents patria jurisdiction. Otherwise, individually to do things for my daughter is extremely difficult for me. I am grateful to all of you, and I would like to pray before both of you that you please take care of my daughter till she becomes a major. We want to give her good education. I don't expect anything from my daughter beyond that she studies well and become an independent girl and comes with flying color. And whatever is needed as a father for her education, healthcare, even marriage, this I have told before the trial court, I will do out of my own volition. And I just pray that both lordships' blessing legally through parents patria should shower on her till she becomes 18. That will be the biggest gift a father can get in this country.
How old is
I have for
she now? How old is she now?
She is
She is just 15 now.
date of birth
25, she will become 18 years.
class 12, my lord. Class 12, she will attain
Oh.
majority.
No, God bless the child, and we are only doing our job in a sense endowed upon us by the Constitution. So, so far, the results have been productive, and
And
both parents have, in their own manner, cooperated, understood their limitations also, and submitted to the jurisdiction of the court. Only then we have been able to do something for the child, and hopefully she will do well. She will have a very bright career and a future. Beyond that, we can't say anything more. Whenever the matter is taken up for hearing, whatever you want to place, make a request.
if it can be as to my lord's convenience, we are ready with our file.
Let the physical hearing resume.
Yes,
and
my
then
lord, because we wish it can be, because that is also what was requested. Probably the counsel from the other side is always impressing that Supreme Court has said that matter be decided on every day. That is their consistent stand. So we are prepared with the file. Once physical comes, my lord, we will just pray. And that one communication, my lord, I will seek leave by an IA that document we want to bring.
whenever it comes, you make a request.
Grateful, man.
Very well. That's all, brother.
Yes.
Thank you.